What is a testimonial statement when dealing with the Confrontation Clause? I'm Tulsa attorney James Wirth, and that is the topic that we have today, dealing with the Confrontation Clause and when it applies. Okay, so the Confrontation Clause is part of the U.S. Constitution. It says that if you're being criminally prosecuted, you've got the right to confront your witnesses, to cross-examine them. So what that means is that if you've got someone who's made a claim against you and they don't want to appear at court and they try to get hearsay in, that could violate your right to confrontation. So there's two different levels here. There's the right to keep hearsay out, and then there's the right to confrontation. Okay, so regarding hearsay, that is a rule of evidence, and it applies in all kinds of different proceedings, whether they're criminal or whether they are civil, and there's a lot within the discretion of the judge on whether to allow that in. There's complicated rules of hearsay, and there's exceptions to hearsay. Okay, that's a rule of evidence. However, in a criminal case, you're not just entitled to the rules of evidence. It goes way beyond that to a constitutional ground of the Confrontation Clause, where the court has less authority to allow different things in. You've got that constitutional protected right. But not all statements come in where you have the protection of the Confrontation Clause. And that comes from the Crawford v. Washington case, United States Supreme Court case, where it says, among other things, the Sixth Amendment right to confrontation bars the admission of testimonial statements of a witness who did not appear at trial unless he was unavailable to testify and the defendant had a prior opportunity of cross-examination. So there's a few limitations here. One, if they are unavailable to testify and there was a prior opportunity for cross-examination, those hearsay statements can still come in and not violate the Confrontation Clause. Where you most often see that is where the person already previously testified at a preliminary hearing, and then the state or the prosecutor shows that they are unavailable for trial, and then they bring in the transcript of the statements from the preliminary hearing. That does not violate the Confrontation Clause under the precedent in Crawford, where it says if they're unavailable and there was a prior testimony under oath where there was an opportunity for cross-examination, then the Confrontation Clause is satisfied. The other thing in there, though, you may not have noticed, is it says it only applies to testimonial statements. So what is a testimonial statement? And for that, we go to another United States Supreme Court case, Davis v. Washington. And it says, in part, statements are non-testimonial when they are made in the course of a police interrogation under circumstances objectively indicating that the primary purpose was to meet an ongoing emergency. They are testimonial when the circumstances objectively indicate that there is no ongoing emergency and that the primary purpose of the interrogation was to establish or to prove past events potentially relevant to later criminal prosecution. So it doesn't just only apply to pre-release interrogations, but that's where you see it happen the most. And that's where we see it happening in the case that I'm looking at today, Charles v. Oklahoma, M. 2022. 174 is decided today. It's not a published case, but it's interesting because it has two claims regarding violation of the Confrontation Clause, and one of them the court determines is testimonial, in which case it should not have come in, and it is an error, and the other one is determined to be non-testimonial, which the court says was not an error because non-testimonial information and testimony can come in even though it's technically hearsay and even though you're technically denied confrontation of that witness. So the scenario in this case is we've got a domestic violence allegation. We've got a complaining witness calling 911, making statements, you got to pick up my boyfriend, he's beating me, things along those lines. And then she did not testify at trial, but they brought in those 911 calls where she says that. Well, that's hearsay. That's an out-of-court statement. And the defendant was denied the opportunity to cross-examine because that person didn't appear to testify at the trial. However, the court found because that's a 911 call describing an ongoing emergency, that is not testimonial. It's non-testimonial, which means confrontation doesn't apply. No error there. All right, so then we get to the part that is testimonial. After the police arrive and they've removed the people and the emergency is over, they're asking her about what happened. Now this is talking about what happened in the past, not what's happening now. Now the primary purpose is not dealing with an emergency, but building a case for prosecution. That's why it's testimonial. That's why you are entitled to be able to confront that witness at trial, cross-examine them, and it was denied in this case, which means that it was an error. The court found it was an error. However, ultimately the court found that the error didn't meet the standard to show that the disposition of the case would have been different but for that error. So the defendant did not get relief, but it's still a good case talking about the differences between testimonial and non-testimonial out-of-court statements. If you're dealing with any of these constitutional issues in an Oklahoma court, you're going to want to talk to an attorney privately and confidentially. To get that scheduled with an attorney at my office, you can go online to makelawEasy.com.